Before Trent Sinclair admitted to murder, he spoke to his lawyer on the phone for about 6 minutes. Following the call with his attorney, Sinclair was then subjected to a 5-hour interrogation, during which officers refused him further contact with his lawyer and falsely claimed that they possessed incriminating DNA evidence against him. These coercive tactics prompt Mr. Sinclair to declare, quote, "You got me, and I know it." Given the pressures and extreme leverage afforded to officers during investigation, does a 6-minute phone call do enough to guarantee our Section 10, subsection B, right on arrest to retain and instruct counsel without delay? Police powers are mostly defined by the Criminal Code. Article 495, for example, states that, quote, "A peace officer may arrest a person without warrant who has committed an indictable offense or who, on reasonable grounds, he believes has committed or is about to commit an indictable offense." Needless to say, when it comes to detention and interrogation, police are given extremely broad powers that are often based on discretion. The courts have recognized that police questioning is a legitimate tool of investigation. They also acknowledge that the authorities have to be able to match the ingenuity of the people they are investigating in order to combat crime effectively. There is indeed no law in Canada forbidding the police to lie to witnesses or to lie to suspects. Section 10 of the Charter protects a person's right to be informed promptly of the reason for their detention or arrest and the right to retain and instruct counsel without delay and to be informed of that right. Its purpose is to provide a person who has been arrested or detained with an opportunity to obtain legal advice relevant to their legal situation. Sounds great in principle, but how does this right play out in real life? Well, prior to interrogation, it might go something like this.
Thank you for calling. You have reached counsel. Keep your mouth shut. Press 1 to repeat this message.
How would you feel if you were given this advice upon request of counsel? Is this enough to get you through a series of difficult interrogative scenarios? What if, after further investigation, new evidence unfolds? Or you are lied to about what evidence the police have found against you? In many of these situations, the advice initially given by counsel might no longer apply to your situation. Although we have many systems of rights and procedures that protect citizens during interrogations, at times it may be difficult to foresee how the players in these systems might actually carry them out. In Sinclair's case, the court majority ruled that you have a right to additional opportunities to speak to your lawyer if there is a change in circumstances which significantly affect your choices. But practically, it is up to the police to decide when this occurs. Your request is not enough. The purpose of Section 10 is so that we are able to make informed choices in our dealings with the police. However, if we do not have the right to have a lawyer present during interrogation, how can we make informed choices without prior knowledge about our options and rights? Effectively, the court used Trent Sinclair's experience in interrogation to expand police powers within Canadian case law and to limit the reading of our Section 10 rights. Given the immense powers held by police to determine when and how we access counsel, could Section 10, subsection B, be interpreted more broadly to restore this power imbalance? Or is Section 10 simply meant to inform us to keep our mouths shut, as the court in this case suggests?